Thank you very much for inviting me and for bringing me aboard this on board this project. I think I got the invitation in early May, and with a deadline looming shortly thereafter. So it's been a bit of a rush, but I'm delighted to participate. My name is Mchangama. I'm the executive director of a think tank called Iustitia based in Copenhagen, and I also run our project on the future of free speech. And I'm trying to sort of sum up an article that I've drafted with a colleague of mine, where we look both at the problem of hate speech online and whether human rights can be, international human rights law can serve as a model for online platform regulation, and specifically how to go about it when it comes to hate speech, where we argue that the intersection between Article 19 and 20 ICCPR is a promising speech robustive one, at least as interpreted in recent years after General Comment 34, but that the paucity of case law makes it difficult always to use in concrete cases. And so we asked, where can we find inspiration? And we've done sort of a comparative analysis between the European Court of Human Rights and the South African Constitutional Court, and so the Supreme Court of Appeal. And now that James is here, I want to run away because I'm afraid that our interpretations of the South African case law will be shredded. But I'm going to go ahead and present anyways. So my PowerPoint presentation is way too long, but so we all know that internet freedom, along with freedom of expression, for more than a decade has been in decline globally under what some call a third wave of authoritization. And what is, and of course, one of the drivers of this is intermediary liability laws, where you could say Germany's NetzDG was sort of the blueprint used and a first mover that has, according to two surveys that we've done, been sort of copy pasted by at least 25 countries around the world. Many of them, including Russia, Venezuela, and others, explicitly reference NetzDG, although, of course, their versions of their laws do not include the same free speech protections, the same rule of law, checks and balances, and so on. So they're basically a bad faith effort of copying a German good faith effort. But nonetheless, we think it's quite relevant to point this out because it provides a facade of legitimacy to some of these laws. It's also interesting to see the possible effect of this development on platforms. Here we see Facebook's removal rates when it comes to hate speech from just around when NetzDG was adopted and up until now. So we see an exponential rise. Now, I'm not saying that this is solely due to NetzDG, but certainly when we've interviewed 8 or 10 platforms, it's certainly part of the equation. This move to basically expand the terms of service, community standards, definition of categories like hate speech to ensure that they're on the safe side, which also means that when you look at the assessment of the pure NetzDG, that might not give the whole picture because most offending content is removed pursuant to terms of service rather than under the NetzDG process proper. So the question is, can international human rights law serve as a framework of first reference when we look at hate speech? And you're all aware of the 2018 Special Rapporteur report. Of course, there are certain challenges. Of course, one when governments adopt intermediary liability laws, they obviously have to observe international human rights standards, at least if they've ratified ICCPR or other relevant conventions. At the platform level, it becomes much more complex since international human rights law is not directly binding, and I certainly would not suggest that an international human rights law approach is a quick fix, or one that can be sort of copy pasted onto. It should be adapted rather than copied wholesale. But if we accept that international human rights law can play a role, then as I mentioned initially, ICCPR is the natural focus point, and there the question of hate speech is of course regulated in the interplay between Article 19 and Article 20. And I would argue that since General Comment 34 from 2011, there's been a move towards a more speech protective interpretation of the interplay between free speech and hate speech, culminating with the Rabat Plan of Action, which has been subsequently referred to in a number of documents. There are 6 sort of elements in the Rabat Plan of Action when determining what constitutes hate speech: the context of the statement, the speaker's position, intent, content, extent, and perhaps most importantly, the likelihood of harm, including imminence. And we have also the Human Rights Committee's case from 2016 in Mohammed Rabat versus the Netherlands, which suggests quite a speech protective standard and a narrow understanding of Article 20, especially when you look at the concurring individual opinions of Sarah Cleveland and Mr. Politi, where they specifically warn against the dangers of very broad interpretations of hate speech, and that Article 20 is narrowly circumscribed. So this is a useful starting point, but given the lack of case law and the paucity of human rights committee cases, Article 20 and 19 are still difficult to use in concrete cases, and therefore, where can we look to inspiration? And the obvious case for many would be the European Convention and the case law of the European Court of Human Rights, because no other human rights court has delivered more cases relating to this area than the European Court of Human Rights. The problem with that, at least from my perspective, is that the European Court's case law is very inconsistent and incoherent. It's also not very speech protective. It's much more, one could say, a German model than a Danish model, if we're to look sort of within Europe between competing speech traditions. So we did a study looking at 60 hate speech cases at the Strasbourg system between 1979 and 2020, and we found that that free speech restrictions have been upheld in most of the cases. So generally a quite low threshold. Now, the other model that we've looked at is South Africa's. And why South Africa? Well, because South Africa is a relatively new democracy, which perhaps more than any other democracy at the moment has to grapple with how to reconcile freedom of expression with equality and dignity, and that is reflected specifically in Article 1620 of the Constitution, but also because the South African Constitution is very open to international human rights law. And lots of cases specifically refer both to the ICCPR and the European Convention. So in the following, I will try to look at various categories of hate speech. One category is that of which we may call homophobic speech, and I've used the European Convention case of Weideland versus Sweden, in which people went to a high school and handed out sort of homophobic flyers, and the court did sort of basically interpreted hate speech as including insulting and holding up to ridicule specific groups of the population, which can be sufficient for the authorities to favor combating hate speech through criminal law, basically. And this we can contrast with the South African case of Kwelane, which is pending before the Constitutional Court. And here you see a much more, I would say, that the South African top courts, at least, the picture is more muddled when you look at lower courts, but one that is very apprehensive about accepting restrictions on free speech, even when it comes to speech that most people who are sort of democratically minded and in favor of equality would agree is appalling and offensive to various groups. And you also see an interesting difference between South African courts and the European Court of Human Rights, in that the European Court of Human Rights uses history, the European history, as an argument for speech restrictions. So basically the totalitarian nightmare of Europe, in particularly Nazism, is an argument for restricting free speech. Whereas South African courts very often use the apartheid era as a reason to warn against free speech restrictions, because censorship and repression was such an integral part of apartheid, of the apartheid rule. And here, so in Kwelane, we see that the harm is important for the court, and basically here the court said that the homophobic statements in question were protected by free speech in the South African Constitution. And then comes a subject which, of course, is very touchy in Germany, the issue of Holocaust denial, which is banned in a number of European countries, and where the European Court of Human Rights has consistently said that such denial of clearly established historical facts are not protected, because basically, and I think this is right, that everyone who engages in Holocaust denial is basically a very thin veneer of engaging in anti-Semitism and Nazi apologetics. So in our analysis, we found that Article 17, the abuse clause, is used very often in these cases, and therefore Holocaust denial falls entirely outside Article 10. We can then again contrast this with the Islamic unity case from South Africa, where once again the court basically dealt with both Holocaust denial and sort of anti-Semitic comments, and the court explained that not every expression of speech that is likely to prejudice relations between sections of the population would be propaganda for war or incitement of criminal violence or advocacy of hatred, which also constitutes incitement to cause harm. So again, we see a higher threshold when it comes to free speech. It seems to take more for the South African court to be persuaded that offending speech can be legitimately restricted. The last case I'll use is the Ferret versus Belgium case, dealing with an Islamophobic Belgian politician who was banned for 10 years for running for public office. Again, we see the European Court of Human Rights using insults, ridicule, saying that insults, ridicule, or defamation is against groups is sufficient to crack down on hate speech. So a relatively broad interpretation, we can contrast this with the Masuku and other from the South African court system, where the court underlined that speech that may be hurtful of people's feelings or wounding, distasteful, politically inflammatory, or downright offensive does not necessarily exclude it from protection. The last case I'll use is the economic freedom fighters, so a very recent constitutional court case from South Africa, where which dealt not with hate speech but with incitement, but where again we see an interpretation of extreme speech which varies, I would argue, substantially from the European Court of Human Rights. It's basically saying when citizens are very angry or frustrated, free speech serves as the virtual exhaust pipe through which even the most venomous of toxicities within may be let out to help them calm down, heal, focus, and move on. And again, we also see invoking the past, the South apartheid past, as an argument for a more speech robust protection. So in conclusion, I would say that especially at the global level, where there are such huge disagreements about what speech is offensive, what speech should constitute hate speech, an Article 20, an ICCPR approach, inspired by the South African model, would be one which I think could serve as a bulwark against the abuse of hate speech to severely curtail dissent and communication on platforms, and one that should be looked into both by the Human Rights Committee when it develops its standards, but also by the platforms themselves to find a more coherent and speech protective approach to the question of hate speech. Thank you very much.